Hello and welcome back. Today we're talking in terms of civil liberties and civil rights. What are their differences and what makes them distinctive? And we know some people use these things interchangeably, but that's incorrect and that's a misuse of those terms. So today we're going to talk about what are our protections vis-a-vis the state and this difference between peaceful protest and violence. As we mentioned in the discussion of the Constitution, the Bill of Rights contains protections from the individual from the state, not from individual to individual. So that's what we need to concentrate first on, is that what we're talking about today, when we're talking about civil liberties and civil rights, is the state. We're concentrating on what are the actions the state has. In these series of lectures, we hope to compare and contrast the differences between the concepts of civil liberties and civil rights and how they are not interchangeable. Quite simply, civil liberties is what this episode or this videotape is about. And the next one and the next series will be about civil rights. Civil liberties, one can think of them as a government cannot do list. Right? These are things that the government is prohibited to do. And these tend to be in the exercise of religion, or they can be in the exercise of due process and a whole host of other things. For example, as I may have mentioned, in my religion, we serve alcohol to children who are about third grade. It's called Holy Communion. Now, that is protected by, that is a religious and a mainstream religious practice. Can I go to the bar with my third grader and say, let's have the same amount of alcohol? Of course not, right? One action is in a protected category, the other is not. And that's what we're going to examine today, is basically what are the differences? How do we define and how do we know in our own lives what is protected practice and what is not? So think of civil liberties, as I said, as a government cannot do list, and the government is prevented to encroach on those activities. Civil rights is different. Civil rights is almost the complete opposite. Civil rights the objective of civil rights is equality under the law. Equality under the law. Now again, as we discussed in Thurgood Marshall's essay, and later on we'll discuss in Frederick Douglass's speech, this idea of equality under the law gives hope, and it gives an objective criteria. So if we're talking about equality of opportunity, if we're talking about equality of due process under the law, those things are achievable. If we're talking about equality of results, that's a much different story. That's very different, because equality of results, especially if we use an economic or monetary criteria, that becomes very, very difficult, because if I have $4 and my neighbor has $4.01, we're not equal. And how can we be equal? And this is the real practical problem of what governments have been established for equality of results have run into. Governments such as the Soviet Union, the People's Republic of China, and others. So today, this is primarily going to discuss, in this tape, we're going to discuss two court cases, Gitlow versus New York and Texas versus Johnson. And if you've done your reading, you know that Gitlow versus New York is about an anarchist, and Texas versus Johnson is about a political protester. What are the objectives for today? Well, the objectives, there are three of them. The first one is to understand the difference between peaceful protests and disturbances of the peace. When is it appropriate for the government to step in and when it is not? The second, understand the difference between civil liberties and civil rights. And we have begun to do that. We've talked and defined civil liberties as a government do not do list, and civil rights as a government must do, right? If we want equality under the law, and in civil rights, it is a government must do list. The government must act in order to have equality of opportunity. The government must act to have equality under the law. And so, again, understand this difference is an objective that we're trying to have for this session. And the third, define and understand the freedoms of the Bill of Rights and who it protects and why. And I started to talk about that when we talked about this idea of the First Amendment, the Second Amendment, and the rest. Many of them are designed to protect the individual from the state, what the government can do and what the government cannot do. So we're going to begin, and the first thing we're going to talk about is this idea of, can the government defend itself? And we talk about that in Gitlow. On page 70 in your textbook, essay number 14, Gitlow versus New York. Now, the facts of this case are very interesting. And again, for the people who have studied American history or world history, you know that around the late 1800s to the early 1900s, there were groups called anarchists. And anarchists are today would be the term for communists or Bolsheviks, right? So, but basically what these people sought was a violent revolution. And they were very, very successful, like in the 1870s, in the 1880s, of assassination. They assassinated czars, Russian czars, American presidents, and important people across the world. And so people started to get concerned, and people started writing laws, legislators started writing laws about how you could thwart this type of terrorism. And so, again, I'm not talking about anarchist is terrorism, I'm talking about assassinations are terrorism. And so on page 70 in our textbook, the authors say that Gitlow versus New York is a landmark case in the history of civil liberties because it basically takes the federal civil liberties and puts them onto the state. In Gitlow, the court ruled that the First Amendment guarantees the freedom of speech and of the press, and among the fundamental personal rights and liberties protected by due process clause of the 14th Amendment. So we're talking about the 14th Amendment, the due process clause, and of course the First Amendment. This was the beginning of the long process that came to be known as incorporation, by which most portions of the Bill of Rights have been construed and incorporated by the courts as limitations on the actions of state governments. So again, we have this, the courts have basically, the Supreme Court has basically said to the states, no, you must enforce, you must protect, the same as the federal government does. All right, so again, if you remember Iraq, right, we'll start with the facts. What are the facts of the case? Well, you have this person named Gitlow, Benjamin Gitlow, and basically he is handing out literature and he's handing out brochures that talk about the violent overthrow and the violent revolution of the United States. Now remember, one of the things that we have to remember is that the Constitution is not a suicide note, that the state will defend itself. The state will, if it's threatened by internal dissension or external invasion, will defend itself, and that's perfectly legitimate role of a government under a limited constitution. So the state of New York indicted Gitlow, convicted Gitlow, and sentenced Gitlow to prison, and he violated the statutory crime of criminal anarchy. Gitlow's lawyers contend that the statute, by its term and application, is repugnant to the Due Process Clause of the 14th Amendment. So again, the 14th Amendment of the Due Process Clause. The statute, and again, when we're using criteria, the statute and the language of the statute is the thing that the Supreme Court is determining. Is this statute repugnant to the Constitution, or is it constitutional? Section 161, Advocacy of Criminal Anarchy, defines it as this, quote, any person who, 1, by word of mouth or writing, advocates, advises, or teaches the duty, necessity, or propriety of overthrowing or overturning organized government by force or violence, or by assassination of the executive head or of any of the executive officials of the government, or by any unlawful means, or prints, publishes, edits, issues, or knowingly circulates, sells, distributes, or publicly displays any book, paper document, or written or printed matter in any form containing or advocating, advising, or teaching the doctrine that the organized government should be overthrown by force, violence, or any unlawful means, is guilty of a felony and punishable by imprisonment or fine, or both. All right, so that is the language that we're going to look to. That is the language that we're going to judge, or at least discuss what the Supreme Court determined. So again, we have our facts. Our facts are that we know that Gitlow was distributing pamphlets. He was distributing pamphlets and these pamphlets advocated the violent the overthrow of the government, by violence. Now, does this mean that if I was teaching a class on Lenin, or if I was teaching a class on Mao, then I could not talk about their doctrines, how Mao's famous power comes from the barrel of a gun? Does this mean that I cannot talk about the Revolutionary War and how the doctrine that the founding fathers used to legitimize the separation from Britain? No, as the court has said. The sole contention here is essentially that there is no evidence of any concrete result flowing from the publication of the manifesto. That's, again, Gitlow's lawyers. And so what he's saying is basically, because Gitlow is such a poor revolutionary, because Gitlow doesn't have any effect, he has no charisma, no one's following him, that it's okay. And I think that's a very interesting argument. Because I'm failed at overthrowing the government shouldn't have to act against me. Well, maybe, maybe not. So again, Gitlow's argument is no one's paying attention. Therefore, I'm not committing a crime. Well, what do you think about that? So I go rob a bank, and because the police catch me, I didn't commit a crime. Or I go rob a bank, and because I didn't get any money, I shouldn't be prosecuted. This is a pretty interesting theory, right? Pretty interesting theory. If I fail to achieve something, therefore the crime should not be prosecuted. Now, one might say, well, we're talking about violent overthrow of the government. That's different than a property crime. Maybe, maybe not. But I think it's a very, very interesting argument. I mean, sort of tongue-in-cheek argument that if you failed to be a revolutionary, you really should not be prosecuted under the statute. And the court goes on to say this, right? The statute does not penalize the utterance or publication of abstract doctrine or academic discussion, having no quality of incitement to any concrete action. It is not aimed against mere historical or philosophical essays. It does not restrain the advocacy of changes in the form of government by constitutional and lawful means. What it prohibits is language advocating, advising, or teaching the overthrow of organized government by unlawful means. These words imply you urging people to action, right? So again, if I want to talk about Marxism, if I want to talk about changing our system of government from a representative democracy to a direct democracy, or even if I want to advocate any type of structural government through the electoral process, completely legitimate. Once I urge people to action, once I urge people to start using violence, that's a different story. The government, according to this case, can move to incarcerate me. So now let's talk specifically about Gitlow and his pamphlet or his manifesto. The court says the manifesto plainly is neither a statement of abstract doctrine nor, as suggested by counsel, mere prediction that the industrial disturbances and revolutionary mass strikes will result spontaneously in an inevitable process of evolution in the economic system. It, meaning that Gitlow's pamphlet, Gitlow's writings, advocates and urges in fervent language mass action which shall progressively foment industrial disturbances and through political mass strikes and revolutionary mass action overthrow and destroy organized parliamentary government. Okay, so this is, again, what is the issue? The issue is whether Gitlow's pamphlet is a historical or rhetorical, right, discourse, or does it advocate the violent overthrow of the government? One is protected, the other is not. I can talk in terms of a historical or rhetorical discourse on the perfect form of government, but I cannot say we should have that and we should go out to the street and use violence to make it happen. The court goes on. For present purposes, we may and do assume that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairing by the states. So again, for the present purposes, the Supreme Court is saying the state courts, the state cannot interfere with freedom of the press nor freedom of speech. Okay, they can't interfere with that. They go on, it is a fundamental principle, long established, that freedom of speech and of the press, which is secured by the Constitution, does not confer an absolute right to speak or publish without responsibility, whatever one may choose, or in an unrestricted and unbridled license that gives immunity for every possible use of language and prevents the punishment of those who abuse this freedom. It is not it is not an absolute freedom. And you see this all the time, right? You see this all the time. You see people who will say something like, for example, right, Madonna said to blow up the White House. Or you have a rapper or somebody saying, go kill the police. Now, what happens if Madonna would have said that and somebody actually the next day would have blown up the White House? This is basically what the court's talking about, right? It's not an absolute freedom. There are things that you cannot do. There are things that you cannot say. One is you cannot threaten the President of the United States. Okay? The institution, the office of the President of the United States. You can say, oh, I hate Donald Trump, or I hate Bill Clinton, or I hate whoever the president is. But you cannot say, I'm going to shoot the President of the United States. That is not protected speech. That's not political speech. So the same is true with all types of language that people use. It is not an absolute freedom. If I say something and somebody who's maybe unbalanced or of a weaker emotional constitution, that person goes out and commits violence on what I said, I may be held responsible, depending on the context in which I use that language about it. And that's what the court is saying. So the first thing they're saying is that freedom of speech is not an absolute freedom. The state, in its exercise of police power, may punish those who abuse this freedom by utterances inimical to the public welfare, tending to corrupt public morals, incite to crime, or disturb the public peace, is not open to question. Again, the Supreme Court says the state government, the local government, the federal government, they all have a right to defend the peace, to defend a movement or people that are trying to disturb the public peace. So if you start, again, if there starts to have people being killed in the streets due to agitation or to a doctrine that they're following, that is not protected. By enacting the present statute, the state has determined, through its legislative body, that the utterances advocating the overthrow of organized government by force, violence, and unlawful means are so inimical to the general welfare and involve such danger of the substantive evil that they may be penalized in the exercise of its police power. So again, what's happening? We have the courts, and this is the issue. The response by the courts is this law legitimate? And they went back and basically said, how is this law passed? It's passed with the legislative powers. The legislative powers of New York State. So it is a legitimate law. Whatever that is, probably close to Article 1, Section 7, where a bill becomes a law. It is a legitimate exercise of the police powers. First of all. What else does it say? That determination must be given great weight. Every presumption is to be indulged in favor of the validity of the statute. Because the legislative power of New York State, and because the governor signed that legislative power, all weight must be given, right? You must basically give them the presumption of doubt. And the case is to be considered, quote, in the light of the principle that the state is primarily the judge of regulations required in the interest of public safety and welfare, and that its police statutes may only be declared unconstitutional where they are arbitrary or unreasonable attempts to exercise authority vested in the state by the public interest. Arbitrary, right? unequal or unequal under the law. That's what the criteria is. So again, Gitlow is advocating the violent overthrow of the government. He is handing out these pamphlets, and the Supreme Court says you should really look to what the state and the local government officials deem what's appropriate. Again, we see this happening in our country today. We see that the power of establishing what is a disturbance of the peace is determined by mayors and governors, and the federal government has to take, and usually takes, a back seat. They have to be asked to help. And so this is what we're seeing. So the question is, does it present a clear and present danger? If I say something, right, or if I write something, and they're talking about, I'm talking about advocating a violent overthrow of the government, are the results, right? If no one ever watches this video and I'm advocating the violent overthrow of the government, does it matter? Or if I keep a diary and I write all sorts of things about what's wrong with the government, and that diary is published, does that matter? And this is really the point of this whole case, because today I may be an obscure person. Today I might be thought of as a nut, but no one knows what future generations are going to do with those utterances, right? No one's going to know. No one knows. And this is where this comes from, right? That utterances inciting to the overthrow of organized government by unlawful means present a sufficient danger of the substantive evil to bring their punishment within the range of legislative discretion is clear. Such utterances by their very nature involve danger to the public peace and to the security of the state. They threaten breaches of the peace and ultimate revolution. And the immediate danger is none the less real and substantial, because the effect of a given utterance cannot be accurately foreseen. The state cannot reasonably be required to measure the danger from every such utterance in a nice balance of the jeweler's scale, right? So what is a reasonable expectation of the state? How does the state determine who's a crackpot and who has a following? You can't, right? It's very, very difficult. So again, if we look at how ideas grow, and again, we're talking about the unlawful. We're talking about the unlawful advocacy, not the lawful. We're not talking about a political party that is trying to let's say a party that is designed to rid the state of the Constitution or amend the Constitution in such dramatic ways that it's no longer recognizable. That is a completely legitimate form of political activity. If you follow elections, if you get elected and you change the Constitution, that's perfectly legitimate. What we're talking about is unlawful action, right? Unlawful action. Now, what's the problem? Is that a lot of people who are, for lack of a better word, radical, they want to radically change our society. They don't want to deal with those processes and the procedures that we read about in the Constitution. They don't want to have candidates. They don't want to go for elections. They don't want to get people to vote because they deem our system is not legitimate. They don't believe in popular sovereignty, rule of law, or tolerance. They believe in something else. And so this statute is directed to this idea of people who want to change the government through unlawful activity, usually violence. A single revolutionary spark may kindle a fire that smolders for a time, may burst into a sweeping and destructive conflation. It cannot, he said, that the state is acting arbitrarily or unreasonably when, in the exercise of its judgment as to the measures necessary to protect the public's peace and safety, it seeks to extinguish the spark without waiting until it has enkindled the flame or blazed into a conflagration. It cannot reasonably be required to defer the adoption of measures for its own peace and safety until the revolutionary utterances lead to an actual disturbance of the public peace or imminent and immediate danger of its own destruction. But it may, in the exercise of its judgment, suppress the threatened dangers in its incipiency, right? So if I'm a state government and I have a concern about the protection of lives and property by the utterances of a person, by the writings of a person, then it is my duty and responsibility to stamp it out so that people don't get killed and property doesn't get destroyed. So the court holds, right? The court decides. That's what the holding of the court, the rule of law now we're at. So we have the issue. The issue is that Gitlow's 14th Amendment due process protections were not violated, and that freedom of speech and the press were not violated. So the court holds, we cannot hold that the present statute is an arbitrary or unreasonable exercise of the police power of the state, unwarrantably infringing the freedom of speech or press, and we must sustain its constitutionality. So again, what is the criteria? Is it arbitrary? Is it arbitrary? Are you just, and again, many people are arguing that what we saw in the summer of 2020 is that the government was fairly arbitrary when it came to the COVID-19 social distancing, when some groups protested and other groups protested. Is it arbitrary? The other argument is that unreasonable. Is it unreasonable to expect? And the court again has said that it does not see it, right? It sees that it is not arbitrary, nor is it unreasonable to have the statute that outlaws what they call criminal anarchy. They go on. In other words, when the legislative body has determined generally in the constitutional exercise of its discretion that utterances of a certain kind involving such a danger of substantive evil that they may be punished, the question whether any specific utterances coming within the prohibited class is likely, and in it and of itself to bring about the substantive evil is not open to consideration. It is sufficient that the statute itself be constitutional and that the use of this language comes within its prohibition. So what are they saying? What are they talking about? They're talking about it is not unreasonable for the state to defend itself. Now again, we're talking in the summer of 2020, and this question of local understanding and state law vis-a-vis federal understanding and federal law. So we look at this idea of legislative action as sort of another criteria of legitimacy. So again, the City Council of Minneapolis, they vote to defund their police department. That is a legitimate use of their political power. Now, the question of how they reached that decision and the question of were the protests peaceful or were they not is a different question. We look to the legislative action. Now, some people want to pick and choose, right? The things that they agree with, they say, oh, that's legitimate and I'll follow that. And the things that they don't agree with, that's illegitimate and I won't follow that. You can't do that. You have to look at, right, you either live by this process or you don't. And so the New York State Legislature they voted and they acted to make anarchy a criminal act. And the city of Minneapolis, right, they passed a law as a response to political street action, to protest, and also to violence. And they did the similar kind of legislative action. Those are the criteria. That is not unlawful, right? It's not unlawful. So these things have real meaning even today. And this distinction between protest and violence is something that becomes more and more relevant as time goes on. It is clear that the question in such cases is entirely different from that involved in those cases where the statute merely prohibits certain acts involving the danger of substantial evil, without any reference to the language itself, and it is sought to apply its provisions to language used by the defendant for the purposes of bringing about the prohibited result. There, if it be contended that the statute cannot be applied to the language used by the defendant because of its protection by the freedom of speech or press, it must necessarily be found as an original question without any previous determination by the legislative body whether the specific language used involved such likelihood of bringing about the substantive evil as to deprive it of the constitutional protection. In such case, it has been held that the general provisions of the statute may be constitutionally applied to the specific utterances of the defendant if its natural tendency and probable effect was to bring about the substantive evil, which the legislative body might prevent. Again, what the court is ruling is was he an effective revolutionary? If he's not an effective revolutionary, then you can't prosecute him. But if he is, then you can. Well, who's to determine that? The court goes on that the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that will bring about the substantive evils, upon which great reliance is placed in the defendant's argument, was manifestly intended as shown by the context to apply only in cases of this class, and has no application to those like the present, where the legislative body itself has previously determined the danger of the substantive evil arising from the utterances of a specified character. Again, the Supreme Court is saying in Gitlow that we are if there was no statute, if there was no statute, then we don't know what the legislative intent would have been. We don't know what the representatives of the people would view as a clear and present danger to the peace. We don't know. But in Gitlow's case, we do know, because there is a statute, and that statute directly prohibits the utterances of unlawful acts, unlawful violence to overthrow the government. So we do know, right? The legislature has defined what is a clear and present danger. What is a clear and present danger? Just as Justice Holmes said, you can't yell fire in a crowded theater, you cannot talk about killing executives, killing members of the government, killing people of official status without creating a clear and present danger. We know this because the New York legislature said so. If you saw the video on federal power, they talked about how when John F. Kennedy went to Dallas and was assassinated, there was no law right? There was no law that said if you shoot the president, the federal government has to step in. That's why the Dallas authorities took the lead on that, if you remember that beginning of that film. Well, the same is true. Basically, the Gitlow argument is the same thing, because what happens is there is a law, right? There is the statute, and that statute gives us basically what the criteria of the clear and present danger. And so Gitlow is a very interesting case because it gives us the idea that there is no limit. That there is a limit on freedom of speech. There is a limit on what you say. There is a limit on what kind of songs and lyrics you record, especially if someone acts on it. And again, what happens is you see a lot of these recording artists or a lot of these celebrities, they say things and they do things until someone actually acts on it. And then they all apologize and they try not to be sued and try not to be prosecuted. And this is the issue, right? How much was it reasonable? If I am a very famous person and I say, like Madonna, and I say blow up the White House, or if I'm a very famous person and I advocate violent overthrow of government, or I advocate the use of violence in political disputes, what is my responsibility? That is a question that, again, begs to be answered. Gitlow, over 100 years ago, started addressing this idea of people advocating the violent overthrow of government. So, what is protected speech? What is protected protest? How do we define it? And that comes in, again, on essay number 22 on page 103 in your text, Texas versus Johnson. Now, unlike Gitlow, the court gives us a criteria of action, even though we may find this action or we may find this speech offensive. So in 1984, the Republicans had their national convention in Dallas, and a man called Gregory Lee Johnson was convicted under a Texas statute punishing a person for desecrating a venerated object when he burned the American flag. So the question is, does burning the American flag is it protected political speech under the First Amendment? So we have the facts of the case. We have a person he burns the American flag. Right in front of the Republican convention in 1984. And he's doing it because it is a symbol of the nation, is a venerated symbol, and he wants basically to get attention, right? He wants to make sure that people notice his message. So the facts are basically there was a group of people that were going from city to city in 1984 protesting, wherever Reagan or the Republicans met, and they were in Dallas, and they had different protests. And at one protest, they were protesting corporations and the Republicans in Dallas. And at one point, someone had taken an American flag and gave it to Mr. Johnson. And then when he was in front of the RNC convention, when they were nominating Reagan, he doused it with kerosene and set it on fire. While the flag burned, the protesters chanted, "America, the red, white, and blue, we spit on you." After the demonstration dispersed, a witness to the flag burning collected the flag's remains, buried them in his backyard. No one was physically injured or threatened with injury, though several witnesses testified that they had been seriously offended by the flag burning. Again, offended, right? And again, in our era, we talk in terms of being offended a lot. People are offended a great deal about a lot of things, and we talked a little bit about that, about freedom of speech. But civil liberties do not protect you from being offended. That's where this idea of tolerance comes in. Now, I am a disabled veteran, and I think the burning of the flag is a very, I would say, immature act, and it offends me. However, I also recognize that this country was founded on the right of that person to do that if they want to. We had a issue here in Orange Coast College about 10 years ago where the student government thought the student leaders thought themselves radicals. They wore the black berets and the things like that, and they refused to stand or give the Pledge of Allegiance before their meetings. And so some of the faculty at Orange Coast College got upset, and they started to have a petition. And a person who's now retired, actually the person passed away, said to me, "Would I sign the petition?" And I said, "I would not." And I asked them, "Is it their organization?" And she said, "Yes." "Were the students duly elected?" And she said, "Yes." And so I said, I may disagree with it, but they have the right to carry on their meetings the way they want to carry on their meetings. And the person who didn't care for me very much said, "I knew you'd say that." One of the proudest moments in my life. And this is the problem, right? This is the problem. See how this case is different than Gitlow. Gitlow is talking about killing people. Gitlow is talking about unlawful overthrow of the government. Johnson burns the flag. Now, again, I would, if I was Johnson's friend, or if I had the similar political feelings that Johnson did, I would say you're going to offend more people than you're going to, right? It's going to hurt our message because people are going to think that we're nuts by burning the flag. You're giving them ammunition to oppose us. But I'm not Johnson's friend, and I don't share his political beliefs. And so he does this. What do I share? I do share a belief in the First Amendment. No one was hurt. This is important to understand. No one was hurt. And no one was threatened. The Court of Criminal Appeals began by recognizing that Johnson's conduct was symbolic speech and protected by the First Amendment. Okay, so this is the first thing, right? Is that the Texas officials said that we recognize that Johnson was dealing with symbolic political speech. That's the first thing they sort of concede on, and that it is protected by the First Amendment. Given the context of the organized demonstration, speeches, slogans, and the distribution of literature, anyone who observed the appellant's act would have understood the message that the appellant was intended to convey. The act for which the appellant was convicted was clearly speech contemplated by the First Amendment. To justify Johnson's conviction for engaging in symbolic speech, the state asserted two interests: preserving the flag as a symbol of national unity and preventing the breaches of peace. The Court of Criminal Appeals held that neither interest supported his conviction. As to the state's goal of preventing breaches of the peace, the court concluded that the flag desecration statute was not drawn narrowly enough to encompass only those flag burnings, and that were likely to result in serious disturbance of the peace. And in fact, the court emphasized the flag burning in this particular case did not threaten such a reaction. The serious offense occurred, the court admitted, but there was no breach of the peace, nor does the record reflect that the situation was potentially explosive. Now again, if we compare this to Gitlow, right? Gitlow was saying, I didn't produce anything. My pamphlet didn't have any results. Therefore, I'm off the hook. Johnson, in the question of a breach of the peace, Johnson did not create. His burning of the flag did not create a disturbance of the peace. Therefore, his contention that it was symbolic political speech is even stronger. Now, again, what can we say? Well, Johnson wasn't overtly talking about overthrowing the government. Johnson was talking about spitting on the American flag, that corporations run the country too much, or some other ridiculous thing, or that Reagan was a Republican. A lot of these people, they talk in terms of being independent, but of course, they never vote for the other party. And so he's not overtly saying overthrow the government, even though maybe his actions are disrespectful and offensive. The court goes on. The First Amendment literally forbids the abridgment of speech, but we have long recognized that the protection does not end at the spoken or written word. While we have rejected the view that the apparently limitless variety of conduct can be labeled speech, whenever the person engaging in the conduct intends thereby to express an idea, we have acknowledged that the conduct may be, quote, sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. So again, the difference between Gitlow and Johnson, right? In deciding whether a particular conduct possesses sufficient communication elements to bring the First Amendment into play, we have asked, and again, this is the issue, an intent to convey a particularized message was present, and whether the likelihood was great that the message would be understood by those who viewed it. So again, Gitlow wasn't doing this, right? So Johnson, was he giving a message? Was his actions basically a message? And did the audience understand that it was a symbolic message? Hence, we have recognized the expressive nature of the students wearing black armbands to protest the American military involvement in Vietnam, of a sit-in by blacks in white-only areas to protest Brown v. Louisiana, of the wearing of American military uniforms in dramatic presentation criticizing American involvement in Vietnam, and of the picketing about a wide variety of causes. Especially pertinent to this case are our decisions recognizing the communicative nature of conduct relating to flags. Attaching a peace sign to the flag, refusing to salute the flag, and displaying a red flag. We have all held, all may find shelter under the First Amendment, right? The NFL players who knelt on the flag, on the Star Spangled Banner. That is protected speech. That is protected speech. The very purpose of a national flag is to serve as a symbol of our country. It is, one might say, the one visible manifestation of 200 years of nationhood. Pregnant with expressive content, the flag as readily signifies the nation as does the combination of letters found in Spelling America. We have not automatically concluded, however, that any action taken with respect to our flag is expressive. Instead, in characterizing such action for First Amendment purposes, we have considered the context in which it occurred. In Spence, for example, we emphasize that Spence taping of a peace sign to his flag was, quote, roughly simultaneous with and exceedingly triggered the Cambodian incursion and the Kent State tragedy. The state of Washington had conceded, in fact, the Spence conduct was a form of communication, and we stated that, quote, the state's concession is inevitable on this accord. The state of Texas conceded for purposes of its oral argument in this case that Johnson's conduct was expressive conduct, and that this concession seems to be as prudent as was Washington's in Spence. Johnson burned an American flag as part, indeed as the culmination, of a political demonstration that coincided with the convening of the Republican Party and its renomination of Ronald Reagan for president. The expressive, overtly political nature of this conduct was both intentional and overwhelmingly apparent. At his trial, Johnson explained his reasons for burning the flag as follows, quote, the American flag was burned as Ronald Reagan was being renominated as president, and a more powerful statement of symbolic speech, whether you agree with it or not, could not have been made at that time. It's quite a juxtaposition. We had new patriotism and no patriotism. In these circumstances, Johnson's burning of the flag was conduct, quote, sufficiently imbued with elements of communication to implicate the First Amendment. So his burning of the flag was, again, protected. The state of Texas goes on and says that there was no actual breach of the peace. The state's emphasis on the protesters' disorderly action prior to arriving at City Hall is not only somewhat surprising, given that no charges were brought on the basis of this conduct, but it also fails to show that a disturbance of the peace was likely a reaction to Johnson's conduct. The only evidence offered by the state at the trial to show the reaction to Johnson's actions was the testimony of several persons who have been seriously offended by the flag burning. Now this is important because we're talking about people who are offended, right? The state's position, therefore, amounts to a claim that an audience that takes serious offense at a particular expression is necessarily likely to disturb the peace, and that the expression may be prohibited on this basis. Our precedents do not countenance such a presumption. On the contrary, they recognize that a principal function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Nor does Johnson's expressive conduct fall within that small class of, quote, fighting words, end quote, that are likely to provoke the average person to retaliate and thereby cause a breach of the peace. No reasonable onlooker would have regarded Johnson's generalized expression of dissatisfaction with the politics of the federal government as a direct personal insult or an invitation to exchange fisticuffs. We thus conclude that the state's interest in maintaining order is not implicated by these facts. It is their bedrock principle under the First Amendment. It is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Again, we have politics and many people in our country today that want to curb free speech. They want to curb it because they find it offensive. As I said in our first session, tolerance does not mean acceptance. If you find something offensive and disagreeable, there are ways to mitigate. Right? There are ways to act under the law, especially in politics. Vote. In holding in Barnett that the Constitution did not leave this course open to the government, Justice Jackson described one of our society's defining principles in words deserving of their frequent repetition. Quote, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by work or act their faith therein. No official, right, can enforce orthodoxy. It's very, very important to understand and remember. We are fortified in today's conclusion by our conviction that forbidding criminal punishment for conduct such as Johnson's will not endanger the special role played by our flag or the feelings it inspires. To paraphrase Justice Holmes, we submit that nobody can suppose that this is one gesture of an unknown man will change our nation's attitude towards its flag. Indeed, Texas's argument that the burning of an American flag, quote, is an act of having high likelihood to cause a breach of the peace, and its statute's implicit assumption that physical mistreatment of the flag will lead to a serious offense, tend to confirm that the flag's special role is not in danger. If it were, no one would riot or take offense because the flag had been burned. We are tempted to say, in fact, that the flag's deservedly cherished place in our community will be strengthened, not weakened by our holding today. Our decision is a reaffirmation of the principles of freedom and inclusiveness that the flag best reflects, and the conviction that our toleration of the criticisms such as Mr. Johnson's is a sign and a source of our strength. Indeed, one of the proudest images of our flag, the one immortalized in our national anthem, is of the bombardment and survived Fort McHenry. It is the nation's resilience, not its rigidity, that Texas sees reflected in the flag, and it is the resilience that we reassert today. Again, by having people protest, by having people articulate their dissatisfaction, does that make us stronger or weaker? I would contend it makes us stronger. The question is, right? The question and the significance of the question is, all right, you have a protest, now what do you do? The so what question. And we'll see what happens. We will see what happens. But in the case of Mr. Johnson, we know what happens. Reagan got reelected by a landslide. And the Republicans went on to dominate the presidency from 1984 to 2008. And the flag burning was an issue. The way to preserve the flag's special role is not to punish those who feel differently about these matters. It is to persuade them that they are wrong. To courageously self-reliant men with confidence and power of free and fearless reasoning applied through the process of popular government. No danger flowing from the speech can be deemed clear and present, unless the incidence of the evil apprehended is so imminent that it may befall before there an opportunity for full discussion. If there may be, to expose through the discussion of falsehood and fallacy, to avert the evil by the processes of education, and the remedy to be applied is more speech, not enforced silence. And again, as we see today, more speech, not enforced silence. That's the lesson of Johnson v. Texas, Texas v. Johnson, right? Is that the symbols of the state, the flag, monuments, these kind of things, if you really want to get rid of them, there are lawful ways to do that. And those lawful ways, you can do that by taking political action. Right? Taking political action, meaning voting, organizing. So again, what I personally believe about the Confederate battle flag, what I personally believe about people like Robert E. Lee and etc. Should those monuments be up? Should you fly the Confederate battle flag? Personally, I don't believe so. I believe the Confederate battle flag is pretty close to the swastika. The Confederacy, if you read the Constitution of the Confederacy, basically it was designed to defend slavery. So it's a natural, I think would be a natural reaction to see that. Robert E. Lee's statue, Robert E. Lee was not one of the heroes of the post-Civil War. Every time people looked to him to help end the Klan, he said no. And you can read Grant's biographies and how Grant, as president, he sends troops down to break the KKK, which he does, and Lee doesn't lift a finger. Longstreet does. Other Confederate generals do. So, and many of these monuments were put up after Brown v. Board of Education. So again, personally, my personal opinion is that I understand why people find these symbols offensive. I might even agree with a protest, personally. But ultimately, this difference between doing something that is going to have a difference and doing something because you want to get on Facebook or you want to be on social media, right? There's a difference there. And for today's discussion, forgive the editorial, but for today's discussion, we demonstrate this difference between Gitlow. Gitlow's trying to advocate the violent overthrow of the government, and the government has every right to defend itself. The government has every right to use its police powers, and of course, police powers we mean, as we defined it earlier, the coercion for compliance. And Texas v. Johnson, where Johnson does something that's offensive, Johnson does something that is incredibly controversial, especially in 1984, but it is symbolic. It is political speech, which is protected by the First Amendment. So this is our first sort of foray into civil liberties, what they really mean, and how they are different than civil rights. Thank you for joining me. We'll see you next time.